Hello, I'm Andy Zajac. Welcome to the program. Defending yourself in a court of law can be challenging. Of course, that's why you hire a defense attorney. But does that defense attorney have the ability to engage and captivate the jury during closing arguments? Remember the OJ trial? We were all riveted really in front of our television sets to see what was going to happen next. Michael Waddington is a renowned defense lawyer and author of the new book, Kick-Ass Closings. Specifically for defense attorneys, this book is filled with everything you need to know to win in court. Michael Waddington joins me now to discuss his book. Welcome to the program.
Thanks for having me.
Now, you have a new book out called Kick-Ass Closing. And by the way, I like that title. Can you tell us a little bit more about that book, please?
Well, Kick-Ass Closings is a book. It's about 500 pages long, and it's called Kick-Ass Closings, a guide to giving the best closing argument of your life. And the book is really designed for criminal defense attorneys, law students, or students that do mock trials. And it's packed with snippets of actual closing arguments that I have used and developed, and also arguments that have been given in some of the most high-profile trials in the past 50 years.
So why did you decide to write this book, and did you have any inspiration behind this?
Well, I go to trial a lot. I specialize in military trials. It's a military system, but it's a federal court system. We don't have sentencing guidelines. So we take almost every single case to trial, which is about 20 to 22 trials a year that I do to a verdict, and those are felony trials. And I start seeing the same patterns over and over. You know, whether it's an incompetent investigation, a corrupt police officer, a cynical prosecutor. And as I'm searching for ways to describe these things to the jury in my arguments, I started doing a lot of research and reading other trial transcripts, attending seminars, and I decided that it would be a good idea for other lawyers who don't have the experience and don't have the ability to go through hundreds of trials to gain that experience, to have like a concise manual where they can go when they need to figure out how to explain reasonable doubt. They could go to this book and look at for reasonable doubt, there's about 25 different ways to explain that to the jury from different lawyers in different cases.
So who exactly is this book for?
Well, really the book is specifically for criminal defense attorneys. If you are a lawyer that tries a criminal case, whether it's your first case or your 300th or 400th case, you can benefit from this book. Because the book is broken down into several sections. The first is a template. And having studied some of the greatest closing arguments over the past 50 years, in doing these a lot, I realized you need a template. You just can't, a lot of lawyers get up there when they're amateurs and they ramble and they just talk and talk. You need a template so you're not rehashing the same material. So the book has a template, and then we broke down closing topics. For example, we have a section on witnesses. Underneath that, there's a section called liars. And we have about 15 different ways to argue and talk about lying witnesses and whatnot. We have sections in there on corroboration of the evidence. We have a section on types of defenses, everything from self-defense. How do you argue self-defense? For example, in that case, I used one of the examples is Mark O'Mara's closing where he describes self-defense in the Zimmerman case, which was a very controversial case. He wanted a full acquittal in that case. But you get the insight into what he argued and what other people argued. Like I use one of Clarence Darrow's self-defense arguments in there, and I use one of my self-defense arguments. So you can look at all these different types of arguments and apply them to your case and your specific fact pattern.
Yes, and from what I understand, there's 310 different closing argument snippets that are in this book from dozens of jury trials. Is that right?
Right. So the book has a total of 310 individual arguments. It's not the entire closing argument from the entire trial. That would not be helpful to the reader. Sure. So what we did is we picked out the nuggets. For example, in the O.J. Simpson case, I went in and I looked at O.J.'s closing, and then Barry Scheck did a closing, and I picked out specific portions that I thought were very well delivered and that could help drive a point home. And I took those snippets and we put those in the book and broke them down by topic and then subtopic. So it's very easy to find what you need. You could really take this book, having never been to law school, and apply it to a fact pattern that I give you, and you can give a closing argument that would probably be better than what most lawyers that have gone to law school would give in a case, just by following this template and using these examples. And I stand behind that. I just think a lot of lawyers don't do the research and have the time and energy to read hundreds of other transcripts. I've done the work for you. You just have to read the book and find what applies to your case and practice it and deliver it.
Okay, so there's no doubt that the defense attorneys who read this book can deliver the really world-class closings.
I believe that if you read this book and you take your fact pattern and you have to think about what your strategy, what your theory is, and you look through the book and get some ideas as to what other lawyers have done in other cases similar to yours, and you modify it. You don't want to take the snippet of the argument and just quote it directly, but what you can do is think about it, modify it to your personality, your style, and your facts, and you can deliver the concepts that are in this book that have been given by some of the greatest lawyers in modern legal history.
So right now, the book is available where?
Well, the book is available exclusively on Amazon. We have the print version, which I have here, and I just want to hold this up to show you. This is a big book. I'm 6'1", and I'm holding this book up next to me in my hands. The book is big. I mean, it is packed with, like I said, almost 500 pages of closing argument snippets. And I didn't mention this before, but these are very helpful, and a lot of lawyers love them. I have a section in there on quotes that can be used in trial. And I broke them down by topic. And one of my favorite sections is about liars. And because in many of our cases, we have to talk about liars. And if the prosecution's witness says something and we disagree with it, or they're not telling the whole truth, we want to be able to give a good quote that sums up what that person is, that resonates with the jury. So the section in there on liars is awesome. One of my favorites is physical, forensic, and scientific evidence doesn't lie. People do. And we use that in a case where the physical, forensic, scientific evidence points to innocence, and then all the prosecution's witnesses point to guilt. And there's another one that I use all the time, false in one, false in all. That's a quote that's in there. And some of these quotes date back to Roman times or Greek times, and they're classical quotes, but they resonate with jurors, and they're easy to use and easy to deploy in court. And the other thing that I wanted to mention is in the book, I also have a section of charts and diagrams. For example, how do you visually demonstrate the standard of proof beyond a reasonable doubt? You can talk about it all day. Some people learn through verbal communication better. Some people learn through oral. Some like a combination of both. So we have about 7 charts in here. One of the charts is similar to what was used in the O.J. Simpson case. We have a chart in there that describes self-defense, states of mind in different types of cases. And it's a chart that shows how high the prosecution's burden is, so the jury can understand visually where the prosecution has to go and how powerful their evidence must be before they find the accused guilty beyond a reasonable doubt.
Well, it certainly looks like a well-written book, and certainly defense attorneys will definitely benefit from this. And I would like to wish you all the best with this book, because I'm quite confident that it will do well.
I appreciate it. Thank you very much.
And thank you for joining us on the program today.
Thank you.
And that's our show for today. Thanks for watching. I'm Andy Zajac. See you next time.